You paid a bunch of money to file for a patent, waited 1 to 3 years for examination to finally begin, and then this happens. Awesome, my first letter from the patent office. Wait, what? You gotta be kidding me. The examiner rejects all of my claims saying that they're not novel and they're obvious over some prior art that doesn't look anything like my invention? You gotta be kidding me. I spent thousands of dollars on this and they reject everything? What the fuck? You gotta be kidding me. Piece of shit, seriously? You. Okay, don't panic. This video is going to describe how to overcome these rejections and how rejections like this are actually a natural and positive part of the examination process and can actually lead to getting a better patent in the long run. The first thing to do is take a deep breath and realize that well over 90% of patent applications are rejected at least once, but that the vast majority of the time these rejections can be overcome and the rejected application will ultimately issue as a patent. In my practice, for example, I would say 95% or more of patent applications get at least one rejection, if not multiple rejections, but that in the end, 98% are going to be allowed and will issue as a patent. So this isn't that big of a deal. Don't worry about it. It's a natural part of the examination process and is actually a positive one. One thing to keep in mind is that patents can be broad or narrow. It's not just a binary thing where you have a patent or you don't. And that's where a lot of this negotiation comes in and why it can be positive. So think about like haggling over buying something, like the shows American Pickers or Pawn Stars. There's natural haggling that goes on, and that's how you reach a consensus between buyer and seller, just as it is in the patent process. So what you're trying to do is you're trying to get the broadest claim scope possible, that is the broadest patent coverage possible, whereas the examiner has to make sure what you have is new and non-obvious over the prior art. And by broad, I mean your invention covers a lot of different variations in the patent, okay? So your claims read on a lot of different variations of things. Whereas on the other hand, you could have a patent that is so narrow and so specific, and yes, you have a patent, but it's effectively worthless because nobody would ever infringe on it because the requirements for infringement are so specific. So before I get into some specific examples of how to respond to novelty and obviousness rejections, if you're getting some value out of this video, please give it a like so you can support the channel and help get this video viewed by more people. So let me give you a theoretical example of how examination would go if it starts off with a novelty rejection, which matures into an obviousness rejection, which can be overcome and then lets the application issue as a patent. So let's say you have patent claims that define your invention as having elements A, B, and C. Okay, the patent examiner would do a prior art search, and let's say they find this piece of prior art that has elements A, B, and C. So the examiner would then be able to form a novelty rejection saying, well, your invention as claimed with elements A, B, and C, it's not novel because there's this one piece of prior art that has elements A, B, and C as well. Okay, so how do you respond to this rejection? The examiner is going to write this up formally in an office action, send it to you and your patent attorney, and then you have to respond. So the way you can respond is two different ways. So you can argue against the rejections or you can amend the claims to differentiate over the prior art. So as far as arguing goes, maybe the examiner is wrong about the prior art, they're misinterpreting it. So the examiner says, well, okay, I found elements A, B, and C, and then you say, well, okay, element C is not analogous to what we have in our claims. The prior art is totally different. That's not the same. Or vice versa. So for instance, the examiner says, oh, here's elements A, B, and C. It reads on your claim elements of A, B, and C. And you say, well, look, you're interpreting our element claim C as being this. It's totally different from that. That's not at all what the prior art teaches. So that is arguing against the rejections. Alternatively, you can amend the claims to differentiate over the prior art. And how would this look? So for instance, again, you have elements A, B, and C in the prior art. You have elements A, B, C in your claims. And let's say, okay, it's fair. It kind of shows that. Well, you have to look through your description and your drawings to find some sort of new element that isn't taught in that piece of prior art. Let's say you do your searching and you look through it and you say, oh, hey, here's something that differentiates our invention over what is taught in the prior art. So the prior art shows elements A, B, and C, but it doesn't show this other element D, okay? So what you do is you amend the claims to recite A, B, C, and then you add D. So what you'll do is you will draft these claims amendments in a formal response, file that at the USPTO, and then the examiner will have to do a new prior art search, will have to consider your arguments or your amendments, and then will issue another office action. So you get this second office action and you're disheartened because your application is rejected again. But don't worry, you're gonna be able to overcome this, okay? So what you end up doing is, so again, you have your claims that say elements A, B, C, and D. Examiner has found two pieces of prior art, one with A, B, and C, one with D. So how do you overcome this obviousness rejection then? It's the same thing essentially as you do with the novelty rejection. First is you're gonna look at the specification and drawings of your application and to try to find some other things that differentiate over both of these pieces of prior art. And let's say you and your attorney, you're looking through, you're doing searching, you say, oh, look, I found something. I found this element E. It's not taught in this first piece of prior art. It's not taught in this second piece of prior art. So let's amend the claims to recite A, B, C, D, and E. Okay, that is one option. Alternatively, just as with the novelty rejections, you can argue against the rejections. Maybe the examiner is misinterpreting one or both of the pieces of prior art, or is misinterpreting some of the elements of your claims, and you can argue against those rejections. But if that's not a viable option, you can amend the claims. Like I said, you add this element E. Okay, so you draft up your response. Maybe it has some arguments. Maybe it also has this amendment that adds element E, and you file that response. Okay, the examiner then picks it up, does a new prior art search, and can't find any prior art that has elements A, B, C, D, and E. Can't find anything with this E. Okay, so the examiner would say, okay, it's novel because there's not one single piece of prior art that shows elements A, B, C, D, and E. And it's not obvious because I can't find any other piece of prior art that has this element E as well in combination with these things. So the examiner would then issue a notice of allowance that would set a timeline for you to be able to pay an issue fee. You pay this issue fee, and then your application will then shortly after issue as a patent. Now in this theoretical example, the case only received 2 office actions and then was allowed. But sometimes it can take a lot longer and there can be a lot more rejections and a lot more back and forth with the examiner. I mean, it is not uncommon for cases to have 5, 6, 7 office actions and maybe not even get to allowance. This is especially the case in patent applications that aren't set up well from the beginning. So click on this video right here. This will tell you how to set up patent applications for getting really efficient examination so you get the broadest claims you can, but with the fewest office actions as absolutely necessary.